Hi, I'm attorney Eric Traben from Lucid Legal. I'm a former state of Florida prosecutor, and I serve as a criminal defense attorney working throughout the state of Florida. One of the things that people often have heard about when it comes to criminal procedure is the right to a speedy trial. Both the U.S. and the Florida constitutions provide an individual with the right to a speedy trial. But what does that mean? Well, in Florida, that means that a person has the right to have a trial commence, or they have the right to have their trial start within a certain amount of time from when they are arrested. The Florida rules of criminal procedure provide that in misdemeanor cases, a person has a right to a trial within 90 days from the date of their arrest or served with the filing of charges. Those same rules provide that in felony cases, a person has a right to a speedy trial of 175 days. The rules of juvenile procedure provide that in juvenile delinquency cases, or cases where minors are charged with criminal offenses, speedy trial time period is 175 days, regardless of whether or not it's going to be a misdemeanor or a felony charge. What does it mean to say for the trial to start? That literally means the first phase of a criminal trial in which a jury is sworn into a criminal case. Once that jury is sworn, the right to a speedy trial is satisfied. But most cases are not going to hinge on whether or not there's a right to a speedy trial that's satisfied or not. And there are a lot of different reasons for this. First off, any delay attributable to the defense is going to count as a waiver of the right to a speedy trial. So the defendant showing up late or missing court counts as a waiver of speedy trial. File a motion to continue, that also constitutes a waiver of speedy trial. Now, the fact is that even if that time frame from the rules is violated, that's not some kind of magic line that makes everything go away. If the state violates a person's right to a speedy trial, that won't automatically make the charges get dismissed. Instead, it's the job of the defense to file a notice of expiration of speedy trial. When a person files a notice of expiration of speedy trial, the court has to hold a hearing in which they determine whether or not the speedy trial rules have indeed expired. If it's determined that the speedy time period has expired, then no matter what, the court must set a trial within 15 days of that notice of expiration. That extra 15 days is referred to as a recapture period. It's a grace period where the state has additional time to obtain their witnesses, to get ready for trial, and to commence the trial and to start, even though the right to a speedy trial is expired. So in a way, filing the notice of expiration of speedy trial might be a big gamble. There can be a big payoff if the state's not ready, if witnesses are unavailable. But a defense isn't always necessarily going to know that. They're not going to necessarily know what's going on in the personal life of the police officer who pulled someone over for a DUI, or whether a victim in a robbery case happens to be on vacation. On the other hand, it's really important to recognize that Florida rules of discovery give far more rights to criminal defendants when it comes to being prepared. Not every state, for example, allows the criminal defense to conduct depositions of the witnesses. And so it's really important that a defense attorney exercise all of the rules to the advantage of their client, to be prepared as much as possible. People have a right to not be blindsided or ambushed when they go to trial. But unfortunately, if a person wants to initiate their trial right away without having had the opportunity to question all of the witnesses in advance or to go through all of the evidence that may be available, then they're sacrificing good preparation and knowledge of the case for a gamble. That gamble might pay off, but the truth is it has nothing to do with whether or not the attorney is a good or a bad lawyer. And it has everything to do with luck. Take, for example, a traffic ticket. In a traffic ticket, if a cop doesn't show up, most of the time that means that the traffic ticket is going to be dismissed, because it can't be proven that the traffic offense actually occurred without the police officer to testify. Traffic tickets are pretty low stakes, and it's not uncommon for a police officer to maybe be unable to attend a traffic hearing, and so the ticket gets dismissed. But in a criminal case where a person is facing jail, the stakes are much higher. There might be other witnesses or civilians who have an interest in what happens and speak up. You have a prosecutor who will also be active and involved in preparing witnesses and trying to ensure that people show up, because it's the prosecutor's job to prosecute and try to convict the criminal defendant. And so you shouldn't treat a criminal case the same way that you treat a traffic ticket and just base it on the hope of showing up or not showing up. In any criminal case, people want to know, what are the odds of something? And although we can try to use our experience and our knowledge to get a feel for whether or not we think something is strong or weak, it is literally impossible to be able to apply any kind of mathematical precision in calculating odds. And in fact, it would likely be unethical to do so. However, we can get a good sense of whether or not a particular strategy may or may not be a good idea. And when it comes to matters of strategy, that's something that's going to be really a decision entirely between the lawyer and the client. Now, in an ideal situation, it's always preferable to try to preserve that right to a speedy trial as much as possible. But again, I would never want to sacrifice good preparation of a case for a gamble or a Hail Mary that maybe someone's not going to show up, right? That's not a sign of a good lawyer, because that doesn't involve any actual work of the lawyer. That's just hoping someone doesn't show up. On the other hand, we have to consider that if every case went to trial, the system would likely collapse. The judges and the prosecutors know this. And there are things built into the system to try to encourage waivers of speedy trial. Now, as we mentioned before, felony cases have a nearly 6-month speedy trial time period, specifically 175 days. In a previous video, we've talked about arraignments and what happens at the arraignments. As a short recap, at an arraignment, a person is informed of the charges that they're facing, and they get additional court dates, including a tentative trial date. It's not uncommon for judges to set that tentative trial date well within the speedy trial period. That way, they know that that trial won't violate a person's right to a speedy trial, but they also know that it may not always be possible for the state and the defense to coordinate all of the things that they would need to do. For example, when it comes to depositions, the defense attorney has to schedule those depositions. They have to coordinate their schedule with the opposing attorney. They have to make sure a witness is available and subpoena those witnesses. So it's entirely possible that scheduling a deposition may fall outside of that speedy trial period. Or another example is if the defense has a really great motion. If one has a motion to suppress where they want to try to get evidence thrown out, but if you have a motion to suppress where you want to try to throw out evidence, and the only availability on the judge's calendar happens to fall outside of the trial period that the judge set for you, you're going to have no choice but to ask for a continuance, and that will likely require a waiver of your speedy trial. So that's another example of why you wouldn't want to sacrifice preparation and the filing of motions for your case in the hopes of gambling that no one's going to show up. In another video where we talk about depositions, we address that in general, people are not allowed to have depositions in misdemeanor cases without court permission. So in a case where there are no depositions, there is a lot less stuff that needs to be done. And if all of the evidence can be obtained and reviewed in advance, and any pretrial motions satisfied within that time period before the case goes to trial, then certainly a defense should make every effort to preserve that right to a speedy trial. Why give up a weapon that could be used to a defense advantage? But because it is so rare that violating a speedy trial right actually results in a dismissal of charges, it's not the most important thing in the world. It's certainly not more important than good preparation, reviewing all of the evidence, speaking to witnesses when possible, and filing appropriate pre-trial motions when necessary. But in general, if you can try to preserve your right to a speedy trial, in an ideal situation, you should do so if possible. But at the end of the day, if you have to waive your right to a speedy trial so you can do any of these other things we've talked about, then don't sweat it, it's worth doing. As an interesting piece of trivia, waiving a right to a speedy trial is one of the few decisions in a criminal case that can be made exclusively by the lawyer over the opposition of their own client. And the reason for that is because that really does relate to a tactical or strategic decision when it comes to preparing for a criminal case. And that's a decision that ultimately rests with the lawyer, who is the professional and is the one that's handling the representation of the client in a criminal case. And so there have been times where criminal defendants say they don't want to waive their right to a speedy trial, but the defense lawyer, often it may be a public defender, says, "I'm sorry, judge, I have no choice but to ask for a continuance. I'm not prepared." And in that situation, the judge will waive the right to a speedy trial over the objection in favor of the defense attorney, because preserving the effective assistance of an attorney to the client is paramount, and the judge doesn't want the case to come back on appeal. There's no reason to worry about waiving one's right to a speedy trial, because the rules actually provide that one can always re-invoke a demand for speedy trial, which will restart a clock for speedy trial in criminal cases. Now, there's a word of caution. When a person does invoke a demand for speedy trial, that person is essentially saying they're ready for trial now. They have everything they need, which means they're giving up any additional information that might come in late. If there's any late discovered evidence, the state doesn't necessarily have to provide that to the defense, because the defendant has already said that they're waiving it by claiming a demand for speedy trial. In most cases, defense attorneys are very comfortable with waiving a right to a speedy trial, but they don't necessarily think it's wise to re-invoke that demand, because any evidence that might get discovered later on will now no longer have to be turned over to the defense. That's it for today about talking about the right to a speedy trial. I hope you've enjoyed it. Make sure that you like this video and be sure to subscribe to our channel for more news from Lucid Legal. Don't forget to leave comments on the YouTube channel. If you have any questions, who knows, maybe your questions will be answered on our next video.